Here's the problem. Every day, 137 people die in automobile accidents on U.S. highways. And every day, 14,000 others die from heart attacks, cancer, or other causes. Think about that for just a moment. More than 14,000 people of all ages, die every day. And every one of these 14,000 people leave their families with all of their financial obligations, all of their legal liabilities, and the responsibility for numerous decisions. Decisions that can result in unnecessary expenses, taxes, and debts. Decisions that can impact the lives of their dependents and alter family dynamics for generations. Like who will become guardian of their children if both parents die in a car accident? Or who will care for a disabled or special needs adult when elderly parents pass on? Or who will make health care and financial decisions for someone in a coma? Or for someone who is mentally incapable of making decisions for themselves? And how will debts or taxes be settled? How will property rights be transferred? And how will assets or income be shared? Decisions like these quite often result in contentious arguments and dissension, even animosity, among heirs, creditors, and business partners. Tying up income and assets in probate courts for years, or subjecting property rights to contentious litigation, resulting in court mandates or asset liquidations for pennies on the dollar. Unfortunately, this sort of thing happens all the time, even within the most amicable families and business relationships, because we live in a legally complicated and financially complex world. And most of us simply don't take the time to consider all of the legal and financial consequences of probate, inheritance, property transfers, income provisions, and asset conversions, as well as the emotional impact and long-term implications these decisions will have on the people we love. So how can we be sure that the right decisions will be made? And how can we protect our families from inheriting our financial obligations and our legal liabilities? With end-of-life directives. End-of-life directives are the careful arrangement, provisions, and instructions for how you want everything handled when you pass on. From life support to organ donation, to your funeral or memorial service, from beneficiary designations to the financial security of your dependents, and from asset valuations and property transfers, to protection against legal liabilities and potential tax implications, from a charitable bequest for your religious community, to an educational endowment for your college or university. End-of-life directives enable you to control what happens after you're gone to the people and things that are important to you. That's why it's different for everyone, but it always begins with organizing all of your records and discussing all of the what-if scenarios with a qualified end-of-life professional, like the advisor or consultant who asked you to watch this video. And the entire process need not cost much money or require more than a few hours of our time. But it is something that all of us need to do, regardless of our age, our assets, or our liabilities. And it isn't something we only do once and forget about, because tax laws change, family situations change, business issues change, debt obligations and asset values change too. That's why our arrangements, provisions, and directives need to be reviewed every 3 to 5 years throughout our lives. So ask yourself this, knowing that you could be one of the 14,000 people who die every day, and that your family will inherit all of your financial obligations and legal responsibilities. Does it make good sense to put off making your own end-of-life directives, or put off a review of your end-of-life directives? Or does it make better sense to consider all the issues, including property transfers, income provisions, asset conversions, and tax obligations, make all the arrangements, and put together all the proper documentation right now with the help of the end-of-life specialist who asked you to view this video?